Good morning.
How are you?
I'm all right, as good as we can be in Melbourne at the moment. How are you going?
Not too bad. It seems like we've got a bit of echo here so far, I've got to tell you. I can hear a bit of echo. Can you hear echo, Karen?
I can hear you next door, yes.
Maybe that's the echo. So what do you think? We're back in lockdown, Karen, you and I.
Yeah, you got to do what you got to do. I mean, I think it gets a little bit harder. Personally, I think I mentioned last time, I find it a little bit more difficult because I'm a bit more tired, but you know, maybe, I don't know how others are feeling. Would love to know how you're all coping, but look, it is what it is.
Yeah, now look, we were meant to go out, Georgie, Alethea and I, two of my daughters, were meant to be dinner at 7:45, and of course we didn't go for the 15 minutes. Instead, we stayed at home. But I think, Sophie, this is how we respond to lockdown. There you go. We're coming back to our old habits of how we manage lockdown, which is having silly Zoom calls with each other. We better get that off. Doesn't look too close, does it? But other than that, let's jump into some of the things that are happening. And for everybody who is in lockdown, look, I'm sorry, it's a tough time. I know our staff are already struggling again because it's their 6th in Victoria. It's first for our Sydney people in a major way, but theirs has been protracted and really very difficult for them. So Zoom calls with silly hats as a start, but there's many other tricks we've got if you want to know them. Probably the biggest thing that's happened in the last 2 days is the WorkPac decision, which is WorkPac, Risotto, Skene, and a number of other cases around the meaning of casuals. The law has drifted on the meaning of what is a casual over the last 5 years. So there used to be a difference between a casual at common law and a casual under the award. So if you were described as a casual under the award, you would be a casual even if you were a casual for 10 years. If it was a common law and you had a continuing expectation of work, after about 6 months, you were deemed to be permanent. So the Fair Work Ombudsman used to work within those boundaries, so did the Fair Work Commission. What WorkPac did was sever the difference between common law and award employees and make everyone a common law employee effectively. So there became a whole number of cases around people who were on repetitive casual contracts, lengthy casualisation. We saw the Fair Work Commission trying to adjust by having conversion clauses going into a number of awards. We've seen Morrison government now affect that as a matter of legislation. So none of us suspected when WorkPac came before the High Court, which is a mixture of judges have been appointed over a 20-year period, but there is without doubt a preponderance of those now appointed by Liberal federal governments. No one really expected quite what happened. And that's for a very simple reason. What the High Court said is, it's what the contract says. It's not the substance of what someone's doing. It's what the contract says. Now, can I just tell you how dramatic this is? Because I don't want to underplay this, because it's going to affect everything we do in workplace law forever until another High Court turns it over. What it basically means is the test in employment law has always been, what is the substance of what the person does? Now, we know that about independent contractors. We know that about casual employees. Okay, the test is, what do they actually do? What the High Court has said is it doesn't matter what they do. If the contract has these key words, then they will be a casual employee, even when they're in substance not a casual employee.
So this is a really big piece, Andrew, and I think we're going to spend some more time over the next week breaking it down for our community in terms of what it means and what they need to do. But certainly, just so you can clarify for us that any business at the moment who has casual employees, you need to stop right now and go back and have a look at what documentation you do have. And in fact, I think the documentation you do have, if you have any, is inadequate.
It's unlikely to have the words the High Court has specifically used, and those words create precedent as a matter of law. So the utilisation of those words in that structure create. Now, for all our clients, you've already got the article that came out from Matt and Nina. If you haven't got the article on it, just email in and Soph will get it out to you. There's two parts to that I want you to know. There is a contract you can use that complies with the High Court authority now, okay? And there's nothing wrong with using it. Secondly, there is a whole process and system around how you employ casuals, which is why I want you to talk to Karen. I mean, that's where Karen works with a number of organisations building the systems that sit around it. It's not so much policies and procedures, it is the system engagement, because the biggest problem we have, and we deal with it every day, is people issuing contracts which is substantially not correct for the person who engaging them. They use templates and they just flick them out and don't think more about it. So you've got your points of access. Nina and Matt can help you with the contracts. Karen can help you with the system. But can I just say this is world changing? This isn't a small change in workplace law. This is the biggest change in workplace law driven by a court in 50 years, because it turns the whole intention of workplace law on its head. The reason we have enterprise agreements and awards is to offset the bargaining power of employers over employees. Okay, we've got a system that says we know that employers have a greater power than employees. Therefore, there is this collective bargaining methodology that exists to even that pressure up. What the High Court said is an employer can issue a contract that overcomes that. That's huge. Like, that's as big as it gets. All right. So next week, we're going to really break that down, and we'll have some documents about where we think that goes, not just in the casual contract. What does that actually mean in relation to things like independent contractors? How important are these processes going forward? I think it's really big. So next week, we promise to bring you this latest on where it flows from here. In the meantime, you go.
Yeah, you know, I'm okay. I'm just thinking it's been quite an eventful, I think, 24, 36 hours, I mean, aside from lockdown and that decision, but also the SPC, which we're going to jump onto now as well, Andrew.
You like the cut? Sorry. Okay, yeah. The SPC have done something which, got to say, it's brave. They've mandated vaccination for all their workplaces. And one wonders what drugs they were taking when they did it, because it neither complies with the left or the right of politics. The right of politics from Scott Morrison is we will not legislate or support any attempt to mandate vaccination, even in healthcare setting. The left, unquestionably, when you see through the union movement, is that workers have a right to say no to things like vaccinations. They cannot be forced into doing it. Now, what SPC did is it failed to consult. It doesn't have a case that sits clearly around it. But quite understandably says, look, with lockdowns the way they're going, if we don't have a mandated vaccination, we could continue to lose a lot of time and we could endanger our employees. So it's all come from a good place in SPC. I totally understand where they're at. What I'm saying to you is the AMW don't feel the same. And they're not healthcare workers. The levels of risk that are being imposed are on tins of fruit. That fruit's unlikely to get sick and die. It's not the high risk place that you'd expect it to happen, and it doesn't differentiate in risk between office workers and people who have higher levels of exposure. So I don't know where this goes, Karen. What I do know is this is a debate, and if I was SPC, I wouldn't have put my finger in the water first, because I don't have the most compelling case for it.
Yeah.
And I'm so against the two major forces that exist at the moment of the left and the right in politics. No one's going to thank me for doing it. But I totally get why they've done it. So I think it's a watch this space, isn't it, really?
It is watch this space. And I think for a lot of employees at the moment too, Andrew, they're probably wondering right now, look, what more can we do? Because we want to be part of this, encouraging people to get vaccinated and do the right thing. But how do we, what mechanisms are available to us? What policies, what more? So there are plenty of ideas that you can consider. I know that FCW have rolled out a policy very recently. Do you want to touch on that as an example of that's something that's practical?
Yeah, by the way, Peter Reichenberg said, don't SPC have a workplace issue? And my goodness, boy, are they going to have a workplace issue? So that's a good question. But I guess the thing for us is, like our business has a leave policy, a supported non-accrual leave policy around people going and getting injections, and we encourage and help organise those. And if they're unwell, we'll care for people in that process. SPC have exactly the same policies, really, really good policies around how to encourage and get people there. But we've now got both sides of politics saying lockdowns don't work, it's only vaccination that works. You can't blame businesses for saying, well, if everything else fails but vaccination, shouldn't we as a business say vaccination is what works, because we don't want to hurt people? And I totally get that. And you've seen it throughout the meat industry. But look, if you want some access to policies and procedures and stuff, give us a chat, talk to Karen, because we've got them. And we think it's the right thing to do to support our people to go and be vaccinated. And
just don't be hasty in making that decision, that's all. So let's just consider the whole piece. Okay.
We've jumped, that's sort of 9 minutes we weren't going to expect to have. So let's jump in and move quickly through what the cases are today. one of the first cases we're dealing with is Young and SMYBB, which is the best bottlers case, which is an issue of negligence for high frequency, low impact type of work. This was a guy using a duck knife to cut packaging. It wasn't all that sharp, and he eventually ended up with musculoskeletal injuries. Common law claim was commenced, and the common law claim was successful in the breach of OHS duties around both regulation and general duties of something which a lot of us don't see as high risk. And that misunderstands risk assessment, because when you have high frequency, low impact, it is a high risk because the nature of what you are doing creates a high risk of injury. And not only a high risk of injury, the very type of injury which is not remedial. It's very hard to fix once it's happened. So it's a serious injury. And I guess, Karen, we talk about rotating people and focusing on it, but we don't focus enough on this type of workplace stuff, which should be capitalised out of businesses normally. But all businesses have these repetitive parts, don't they?
They do. And if you've got, if you're regularly conducting risk assessments and maintaining a risk register, and you've got a risk matrix that you use, it will be very simple to work that out and identify what, where they all live. And quite often they are disguised as, oh, look, those MTIs or those first aid incidents they're not really big issues. Because yes, but they occurred 100 times compared to something, an LTI incident, that's equally, if not more dangerous.
Yeah, and I guess for us, what we want you to think about is this. You don't get prosecuted for every safety breach, but it is a cause of action at common law, and it does mean an accepted workers' comp claim. And if you get a soft tissue injury through repetitive conduct, the likelihood of full fixing of that injury, it's not good. So the actual premium impact is massive, greater than introducing the capital to rid yourself of the issue. Anyway, I won't go on because we don't have time today. Next case is a case called Tao and Monards, which was a manager who managed a woman in a way which was just, it's sort of dick behaviour. I wasn't going to say that, was I?
No.
I try so hard not to say, not saying hello to them, being rude. But importantly in this, using a platform which is Slack. That's a platform we use in our business to communicate socially with each other. We have reality shows, books that we read. Our IT is on Slack and says what's happening. It's a way we communicate, but we would never use that as a method of criticism. And in this case, it was used as a method of monitoring and managing somebody. And I think this case means nothing except this. A, the bullying jurisdiction is a joke, because they made a bullying order which said, say hello to the person in the morning. I mean, give me breakfast all over again. Are you kidding? You have to tell people to be sensitive. So it is a joke of the jurisdiction. But what it really said, and I think is important, is don't send messages when you can talk to someone. Because that's what the case is about, which said, don't send messages when you can talk to someone. That's just being courteous and human. But the problem is with the platforms that we have, the technology that's around us, we forget the fact that we're meant to behave like humans, which is to talk to each other. And it's what we should do. So a case without anything other than to say the jurisdiction's a joke, but it does start to raise this issue, the misuse of technology as a method of communicating when proper communication is in person.
And Andrew, if I can add to that, like when we're communicating online or not in person, it's characterless, right? So there's the nuances, the emotion that's not there, and it's very much open to interpretation. And I would dare say that with these type of behaviors, it's like a creep. You start saying things and not saying things. You start thumbs up, thumbs down, angry face, and then you start normalizing that type of communication, and then it gets lost in terms of what the true message is. So great tools, but have some guidelines around that.
Yeah, and just remember, we're people. We behave well towards each other. Be good to each other. That means we actually talk, particularly if we're dealing with a difficult situation. We don't send a text. We don't send a Slack message. If you've got a problem with someone, talk to them. What's wrong with that? Anyway, that's probably a bit of something that shits me, but nonetheless. Barbara, I know it's the first day in lockdown, Karen. My language has slipped, and I apologise to everybody. It's been a long day. Barbara and Memtaz Derbis. Another case which you might go, well, Andrew, why are you telling us about this case? It's such a boring case. Well, it's not a boring case. It's a case about a guy who went as an unpaid work experience person, was at a law firm for about 4 months, didn't do any legal work, although he's a trained lawyer, was more observing, watching what was going on. And Thanks, Vicky. Yes, demonstration of being human. Not the greatest human, unfortunately. Did all those sort of things. They said, look, we don't need you anymore. And he brought an adverse action saying, look, I had a workplace right to be there as an employee. You've terminated me. I'm really an employee. Now, what I want you to understand is jurisdictions are different. There is no doubt the Fair Work Ombudsman would have found this is an employment relationship and would have prosecuted it. The Fair Work Commission, depending on who you get and the politics from where they landed, and this person said, well, no, the contract didn't say that you're an employee. And you actually, when I look at the substance of things, you weren't doing employees' work. Okay, therefore, you are not an employee. The short answer after WorkPack is, if you have a policy that's correct and you have a contract that's correct, you will never have this level of difficulty, ever. Okay? But I do want you to understand this. What this case clearly shows is the systems you have and the contract you have, particularly now after WorkPack, are critical in determining who people are. And the reason I stuck this case in is it's a perfect example of what WorkPack now means. That in-between area of, is it a paid employee, paid work experience person, or a work experience? Up to you can do it by contract. I personally think people who use work experience and don't pay them is a pretty bad act. So we pay people according to the order and their work experience. And why do we do it? Because we want them to feel like they're an employee. But I do understand if you don't want to, but make sure your contract's really tight. So what I want to talk about now, that's the cases today. And I know we're running really late and I put a lot of pressure on Karen because we said Karen would talk about pre-candidate checking before we make them an employee. Over to you, Karen, in the 4 minutes you got.
Yeah, okay. Thanks, Andrew. So Sophie, can you load up the slide? Excellent. So this has gone out to you. If not, you'll get it shortly after today's webinar. What we just captured there is a summary, some practical tips in terms of how it is that you identify and validate claims made by prospective employees, candidates around what they've listed on their resume and CV. So what we said last week was that it's about half, we find, based on the research anyway, that about half of people lie or misrepresent themselves in terms of the details on their CV. So this often does not get detected until after the fact. So you encounter that, you know, somebody can't do something when they said they could, or in terms of qualifications or licenses being out of date or never have been obtained. That's not terribly helpful to us at that point in time, or to you for that matter. So there's a couple of things here that I've outlined for you from the skills, experience, qualifications, organisational fit, and some other bits and pieces as well. Now, look, that's for you to have a look at. I guess what I want to spend a moment talking about is it's the importance of getting this done well and truly before you have the conversation about offering the employment. That's because I find throughout what I've seen through my career is that it comes either at the time, if not after the fact. And that's probably the biggest takeaway I want to share with you. But really to also understand that there are tools in place now that you can put in to help safeguard you from this as well. When we spoke about this last week around the use of, which is at this point in time probably uncommon, the use of statutory declarations, but also having very clear clauses in your employment contracts to outline that if you're found to have what you've supplied here is in fact honest, and if there's anything that's inconsistent or found to be untrue, that there's a mechanism for you to manage that. So the point of that being two things: one, making it very clear for yourself and making it very clear to the candidate that what the obligations are, and certainly if there is an issue, that there is it's very clear in terms of setting the expectation that this will be managed and there's a certain outcome for that. Andrew, is there anything you want to add to that?
Yeah, look, the other thing I'd just add is there's a number of cases around the use of LinkedIn, use of social media with privacy settings to actually check things that are being said. I encourage you to go online and look, and if you're able to see it, you know that the personal settings are not privacy settings for the purpose of viewing it. But verifying information is a really important process, and as a lawyer over 35 years, the amount of times that the person that we've employed has not been the person. It's like a dating site, you know, and the person turns up 10 years older when you come to dinner with them. It's a bit like that, you know, because that's what happens. We employ someone and then we're giving them work and they go, you actually don't have that skill. Part of that is the behavioural method of assessing people when we do reference checks. Part of it is actually not going online and seeing what the person was. In one example, would have disclosed it immediately. But I want you to actually spend a lot of time at the pre-offer of employment process, because it is far too late afterwards. And I want you to adopt this. Again, you can chat to our guides and they'll help you with the stat dec thing, and building a structure and a contractual structure that protects you, because otherwise you're stuck with it. All right. Now, what we're going to go on to is I was going to talk to you in detail about what happens as an employer when you get it wrong in the pre-employment process. But WorkPack and SPC stole my time. So what I thought we'd do today is, when we do the case study is not going to be easy today. Can I just say that? But I will spend some time next week talking through, and we'll spend a bit of time this week starting to talk about what the law is. But the example I give you is not an unusual example. So could you put up the case study? Okay. A soft drink company, Sugar King, owned by a multinational beer company, decided to invest significant capital into the existing 3 sites in Australia. Now, Sophie's moved this whole thing around, and I wasn't expecting that first paragraph because that wasn't mine. I think it's going to be a lot better. They approached David, the principal recruiter of findyou.com, a leading recruiter for the manufacturing industry in Australia, to find a national operations manager. The offer was salary of $300,000 plus short-term incentive of 40% per annum and a long-term incentive over 3 years of 100% based on delivery of the business plan. They would be a member of the local executive reporting to the CEO. David approached Jenny, an operations manager at a bottling plant for another well-known soft drink company in Clayton, which employed 230 people. In her current role, Jenny reported to the national operations manager, John, who was a member of the executive. She's on the flat rate of $250,000 per year with incentives around production targets, waste and rework of an extra $50,000. She was wonderfully credentialed for the work, well respected for her innovation around lean, and had previously worked for a large multinational brewery around Europe, learning the ropes. Let's go to page 2. Sugar King offered her the job and she accepted by signing and returning the contract. David said the package would improve annually on review. There was opportunities overseas in the future, and the CEO role would be open in 2 years' time. Jenny's old employer was very unhappy about losing her. There'd been tension between Jenny and her boss, John, as he had sexually harassed her on several occasions, supplier and client functions. John reached out to a friend at Sugar King and said Jenny had a shocking reputation in the current business, was a troublemaker, and they were pleased to lose her. Sugar King became concerned and arranged for her to attend a meeting, explaining they were going to impose a probation period and she would start a role as a site production manager on a lower base, and they would review that in 6 months' time. She'd signed a contract for original job, and that was the original job of the national operations manager, that either could terminate on 3 months' notice, and she would be reviewed annually for short-term incentive and long-term incentive. They offered her a new contract. The original contract had a 12-month restraint Australia-wide, and as a matter of law, it was an objectively enforceable restraint. She immediately wrote a letter saying the company had repudiated her contract, and she accepted that repudiation. In other words, she said they've terminated the contract and she accepts that termination, which is what you've got to do around repudiation. She asked for 3 years' salary and 75% of the STI and LTIs, as the company had said she would have no trouble hitting her STI and LTI. The company offered her 3 months' notice. Okay, let's go to the poll, guys. As I said, hard problem, Karen. We've got a lot of people today, so there's a lot of us locked down at home. So I hope you're drinking a good coffee, because I'm starting to go through coffee withdrawals. Maybe that explains my poor language.
All right, probably another 5 seconds, Andrew, and we can start talking about the responses.
Yeah, okay, very good.
Okay, because that's most people now. Okay, 3, 2, 1. Thanks, everyone. Let's have a look.
Let's have a look at what we've got here. Right, no, that was too big. I've covered the whole screen. I can't see you, Karen. Was Jenny employed under the original contract even though she had not commenced work? the majority of people say yes, and the majority of people are absolutely right. Okay. A contract is enforceable before the actual commencement of work. By her accepting the offer, the company was bound by that contract. Was the offer of the new contract a repudiation of the original contract? And there is a mixture there, really, really good mixture, by the way. So well done, everyone being a little bit confused by it. The moment they said to her, you're not going to do the original role, whether it was the offer of a contract or merely saying we're going to impose a probation period or you're going to work as a site manager. The moment they did that, that's repudiatory. Okay. Why? Takes away the role the person was offered, takes away the responsibilities the person was offered, takes away the remuneration. Any one of those is a repudiation. Okay. Now, how often people offer jobs to people and say you report to the CEO and then they turn up and report to somebody beneath them. Okay. So this is a repudiation and it was accepted. So really well answered, guys. It's not easy. Well, the next couple of questions show how not easy this actually is. So the question after that is, was the payment of notice period sufficient to protect Sugar King from a successful claim for loss and damage? Well, there's a mixture again, and the answer is no. But the answer is based on contract, and you see why WorkPack now is so important in this. See, what the contract said is 3 months notice, but it didn't say anything about misconduct that existed around it. It's just 3 months notice you can give. But what it did say is there would be annual reviews. So a person who signed this contract based on the representations that had been made, and there was no clause in this contract which excluded all past representations, you're now starting to see why that's so important, aren't you? But that meant she had a reasonable expectation she would be reviewed annually. She had a reasonable expectation she would receive a benefit. And without something as to her misconduct occurring, there is no proper basis for her termination before she commenced work. She had done nothing wrong. Now, that's a case called Walker and Citibank, which we'll talk about a lot next week because it's probably the leading case. But in Walker and Citibank, the guy was offered $450,000 and was paid for 5 years at that level. So he won over $2 million in what was a contractual and misrepresentation claim. So the loss here is at least the business plan period of 3 years, because she's done nothing which suggests her employment should have been terminated, and it was likely she would have received a review. Therefore, she had a reasonable expectation of continuing employment unless she did something wrong, and they were confident she was going to go well. So in this case, not only is she entitled to the damages that go to her base pay, but there is a very strong argument she would be entitled to some part of the incentive payments. Pretty scary stuff, isn't it? Okay. So this is why I want to talk to you about what you need in a contract, and WorkPack is going to drive that home next week, how important the contract is. But the last question is, what about Sugar King's restraints? An enforceable one as a matter of law. Is it still enforceable after they terminate her, after they repudiate a contract? Again, you're so right to be a little bit confused, but the case is called Crow-Horwath and Loon, which says if you as an employer repudiate a contract with an employee, you lose the benefit of the restraint. Okay, so that's the law. Moreover, in this case, it could not be reasonable because the person was never part of the business and therefore never enjoyed the type of things worthy of protection by a restraint. So although it would have been enforceable law had she been working, it's not enforceable because she hadn't been working. Because remember, restraints are based on the reasonableness of the restraint. And if she has no knowledge of the business, she has nothing that is worthy of protection. Now, I just did this because this is a problem that comes across our desk probably once every couple of weeks about representations made to employees at the time of engaging them. And I guess, so if you can drop that down there. And I guess the point that I want to make here is, please give a very careful script to recruiters, Karen. That's a real problem, isn't it? Their job is to get a person across the line. And if you give them an open script and tell them, thanks very much, and you tell them, look, we really need this guy, promise them the world, they will. And it'll be bullshit. But they'll promise them, and the person will walk through the door with a reasonable expectation that they're going to get rewards that they'll never get. or they're going to report to someone, they're never going to report to. So the candidate stage that we've talked about, it is critical to get it right before you go out to offer, and then to give a dedicated script to a recruiter who doesn't breach that script. And that's time, Karen, and I've talked across you the whole time.
That's okay.
Everyone, you take care. I'm sorry the world's a difficult place at the moment, but let's hope by next week it's less difficult for all of us. We'll see you later. Bye-bye.
Take care, everyone. Bye now.